This is the final hearing in Cruz versus Cruz.
This is a final hearing in a divorce case. I represent Corey, Leland, Darrell, Cruz. These parties were married back in 2017. So it is a relatively short-term marriage. They separated in November of 2019. They are the parents of one little boy, Corey Abel Elijah Cruz, and he was born in 2017. So the parties have been before the court on several different occasions, sometimes in person and sometimes on Zoom throughout the course of this marriage. But we tried mediation, and I think we resolved a lot of the issues at mediation, but not all of them. As far as my client is concerned, for today's purposes, there is not any personal property in the possession of his wife, I believe, that he states would be his or that he would otherwise be entitled to. He's not aware of anything that he has that his wife would claim as hers or otherwise be entitled to. I don't believe that there are debts that this court would have to bother itself with. My client has his own debts that he's paying, and I believe likewise for his wife. Parties don't own any marital real property. So as far as the divorce itself, Your Honor, I don't really think there's any issue that both of these parties desire to be divorced, and would ask the court for that, essentially on the grounds of irreconcilable differences if it were to please the court. They could stipulate to that would be my client's position.
Can't stipulate to irreconcilable differences under the statute. Irreconcilable differences as a grounds requires a written marital dissolution agreement that resolves all of the issues. I only know that because I litigated a case back in about 1981 that went up after that statute was adopted, and we stipulated irreconcilable differences and then tried the case in front of Judge Birch on a change on the custody, or back then was just whoever was going to have custody. The Court of Appeals went up on an appeal based on what the judge did about custody, and the Court of Appeals vacated the entire divorce and said you can't have a stipulated agreement on irreconcilable differences unless everything is resolved. So for that reason,
okay,
I happen to know you can't do it, but you can stipulate that grounds exist under the statute without a finding of fault on inappropriate marital conduct, and I will allow you to do that if that's what both sides wish to do.
Okay. This is not a spousal support case. I submit to the court. I don't think that's an issue. The court's not awarded any type of spousal support at any point in any of these proceedings. Both of these parties work and earn an income, relatively short-term marriage. So what we're left with is a little child. And so the parties have a parenting plan that's in place now. This court has ordered that parenting plan to be put into effect. And what my client is prepared to submit to the court today, as far as a permanent parenting plan, is essentially a continuation of the plan that's in place now. And we've prepared a parenting plan that we will be submitting to the court for that purpose. It doesn't in any substantial or material way change what the parties have been doing. This little boy has now, over the course of this divorce, settled into this routine with his folks being separated, but co-parenting with him. And that's what we're asking the court to do, is permanently order its temporary schedule, permanently moving forward. Court would need to, my client's paying child support right now, and the court may have to hear some proof about a claim that he may owe some back child support from the day of separation until the day of the court order. And we're prepared to put on that proof as far as the visitation that occurred, whether or not that was being allowed to occur, and then his income during those periods of time. But that's our position, and we believe to be the issues remaining for the parties.
Mr. Jackson?
We do agree that no real property, if neither party has any personal property from the other party. And we are here today essentially to put on proof that temporary parenting plans are covered.
All right. Mr. Sanders,
Yes.
you may call your first witness.
Oh, Corey Cruz, Your Honor.
Cruz, you'll come around and raise your right hand and be placed under oath.
You solemnly swear or affirm the testimony you give this cause to be the truth, the whole truth, and nothing but the truth of God.
You can take your mask off if you want to while you're testifying, so it'll be easier to understand.
Thanks, sir.
Mr. Sanders, you may also if you wish.
Mr. Cruz, would you please state your name for the record?
Corey, Leland, Darrell, Cruz.
And Mr. Cruz, you are married to Miss Jenny Cruz here today, correct?
Yes, ma'am. Yes.
And when were the two of you married?
2017.
And I put you on the spot, but are you able to remember your anniversary?
I believe it was
April. And you all have one minor child together, is that correct?
Mr.
And what is his name?
Corey Abel Elijah Cruz.
And how old is Corey? What do you call him?
Little Corey.
Little Corey. All right, you all share a name. So, and how old is your son?
He's 3.5, expect to be 4.
And is he an otherwise normal child?
Yeah, a little advanced.
Does he have any special needs or
Yes.
any extraordinary disability or anything along those lines?
Yes.
Now, you all own no real property together, correct?
Correct.
And you don't have any, your wife doesn't have any personal property that you think is yours or that you would be entitled to, correct?
That is correct.
Are you aware of anything that you have that she would want or otherwise be entitled to?
I don't believe so.
Any debts?
Yes.
And are you willing to stipulate today, for purposes of this hearing, that there are grounds in existence to grant you all a divorce essentially without assigning fault to either one of you today?
Yes, sir.
And you want a divorce?
Yes.
Mr. Jackson, are you in agreement with you and your client agreement to stipulate the grounds for divorce?
Yes, Your Honor, we'll make statutory.
All right, it does not prevent either party from putting on proof whatever they want to about the conduct of the other party regarding the parenting plan, but it just means we don't have to litigate who did what about the divorce. So, all right, I will grant them a divorce on the grounds of inappropriate marital conduct pursuant to the statute of where they have stipulated grounds.
Now, Mr. Cruz, let's talk a little bit about your son. You all separated when?
I believe it was at the end of November 2019.
November of 2019?
Yes.
Okay. And was there an event that happened that created or caused the separation?
There were several occasions where we would have an argument about something and she would threaten divorce. And it didn't matter how small the matter or large. On my birthday, which was November 10th, she made one more of those claims, and several times before that I had stated, like, you can't keep doing this, like kicking me out, that I'm not able to see my son, etc. So that day, she was like, I want a divorce, etc. I took my son to the park And when I came back, she didn't want to talk about it. And then gave me a date to be out of the house.
Okay. And do you recall what date she told you to be out?
I don't, I want to say it was not that weekend, but the next Friday.
Okay. And did you indeed move out when you were told to move out by your wife?
Yes, I respected her wishes.
And upon moving out, were you able to see your son?
For a very short period after that, yes.
And did something happen to cause you to stop being able to see your son?
Yes, I believe she thought that I still had his birth certificate in one of my files when I had taken my stuff from the property. Which I did, I was not aware that I had. Still to this day, I don't believe I have. But she said until she had that I could not see my son, or we had a court order for me to be able to see my son.
Okay. And I believe that did we come before this court and seek a parenting schedule on your behalf?
Yes.
Do you recall when that was?
Oh gosh. I want to say it was in March.
March of 2020.
Yes.
And I believe that was conducted via Zoom.
That one was actually,
Now, from November until we came to court, did you see your son?
a few times, yes.
And when you say a few times, do you recall?
I want to say it was, I do know.
Okay. Now, we came to court in March and the court put down I think it may have been an agreed order that was submitted, and I don't recall the specifics, but it may have had to do with some COVID issues. Got a parenting plan in March of that year, correct?
Yes.
And then did you all begin to kind of follow that schedule at that point in time?
Yes.
Okay. And then I think we came back a subsequent time, and that schedule was modified slightly.
Yes, I believe
By Judge Phillips.
Okay.
Now, if you would, please tell the court what your present schedule is with your son.
So with my son, I get to pick him up Wednesday night at 6 p.m. The court ordered till Saturday night at 6 p.m. Because I do work in retail, and Jenny has been working with me on scheduling with him. I pick him up at Wednesday night at 6 p.m. and I keep him until roughly about 9:30 Saturday morning, so that she's able to, because she has first right of refusal, to watch him for the remainder of the day.
Okay.
And
So
that's each week.
every week. So your schedule would essentially allow you until 6 p.m. on Saturday night, because you go to work on Saturday. What time do you go in?
I have to be there.
Okay. You have to be there at 10:30 right now. And you work in retail, so your schedule is not up to you.
Well, I am the manager, but yes, I can't just have the weekends off.
Okay. And so you drop him off to her Saturday morning because you're going to work.
Correct.
And is that essentially the schedule that you all have been following now
Yes,
since March?
that is correct.
Governor, may I approach the witness?
You may.
Cruz, I'm going to hand you a document here and ask you if you're able to identify that document.
Yes, this is the new parenting plan.
And is that the parenting plan that you and I met with and created together?
Yes, sir.
And does it, in your mind, reflect the current situation for you in the visitation schedule that you've been exercising?
To the best of my knowledge, yes, sir.
It would allow you Wednesday at 6 until Saturday at 6, just like has been ordered. It also provides that you all would be able to do a visitation schedule outside of that if it was otherwise agreed upon. Have we just divided kind of on a standard basis, the parenting, the holidays,
That's good. Yes, sir.
and that you all would equally divide the breaks, fall break, spring break, and those things.
Absolutely.
And we've also made an allotment that you all would each have 1 week in the summer.
Yes,
You all meet at the Dixon Police Department right now, correct?
yes, sir.
Or if you all agree otherwise,
I was gonna
y'all may meet somewhere else.
Yes.
And we've provided for that. Would you like joint decision making with respect to your son?
would like to.
Okay. And there was one error in the original that I fixed, and it contains your initial, correct?
Correct.
That your wife is the parent receiving child support,
That is,
and we had the wrong box checked. You would like to alternate claiming the child on your taxes?
I would, yes, sir.
I believe she carries health insurance, correct?
Currently, yes.
And I'd like to move into evidence, my client's proposed parenting plan.
All right, we'll mark that as Exhibit 1.
And Mr. Cruz, we didn't totally cover this, but what is your address right now?
504 Winchester Circle, Dixon, Tennessee, 7055.
504 Winchester Circle. Was that an apartment?
It is.
And do you rent that apartment?
I do.
And how many bedrooms are in that apartment?
2 bedroom.
And I'm assuming you have one and your son has one.
If he chooses, yes.
Sometimes he stays in your room, or
Or we, hang out a little because we'll watch movies.
and are you two the only two people living there?
Yes,
And he's been there multiple times since his court order visitation. And does he like it there?
he does.
Have toys and his things that he enjoys doing there?
Yes. Okay. Go forward.
How far do you live from your soon-to-be ex-wife?
I believe we're max 6 minutes away.
6 minutes away from one another? And where do you work?
I work for K Jewelers.
K Jewelers.
Greenhouse Mall.
And are you paid by the hour?
No, I'm actually salaried.
What's your salary?
I believe it's 48.
48,000 a year. And what is your schedule?
Right now, my company is allowing me through HR to have Thursday, Friday off to accommodate my schedule with the court appointment for my son. So basically, I'm 11 to 7 Monday, Tuesday, and then Wednesday I get off at 5 so that I can drive back to Dixon to pick him up. Off Thursday, Friday, Saturday is 11 to 7. I have to be there 10:30, and then Sunday is 12 to 6 currently, but the mall is trying to lose.
Okay. You said that a little bit fast for me.
Oh, I'm so sorry.
I don't know about the rest of everyone. On Monday, what's your schedule?
11 to 7,
Tuesday,
11 to 7,
Wednesday,
11 to 5.
Thursday,
I'm off.
Friday, you're off.
Yes, sir. Saturday is 11 to 7 as well. And Sunday is 12 to 6.
And so the current court order, it allows you have both of your days off, correct?
Yes,
You also have Wednesday night, you pick him up, correct? You're off, and then you take him back to her on Saturday,
I do. Yes,
and you do that each and every week.
that is correct.
Now, in your estimation, how has that schedule gone?
I feel like it's worked really well. I mean, at first I was a little worried about it just because of work and everything else, but it's actually turned out pretty good. With her being off on the weekends, she can actually spend that time with him. That's really what I wanted, was whatever time that he spent with us, he spent on our days off so that he gets more one-on-one time.
Now, would you like for the court order to reflect that You both have that right to parent your son if the other requires daycare.
Yes, I read
That you have that first right to say no if you have something to do.
Yes.
Now, how is your relationship with your son?
I'd say it's pretty awesome.
Are you all well bonded?
Yeah.
Does he enjoy spending time with you?
Absolutely. Yes.
Is there any hesitation when we go to pick him up or anything like along those lines? Now, the truth is, Mr. Cruz, you would love to have more time with your son if that was possible. Correct?
Absolutely.
But given your station in life right now and your job, the current schedule, do you feel like that maximizes the best and quality time that you can have with him under the circumstances?
Absolutely.
Okay. Now, Ms. Cruz, do you know her work schedule?
I mean, it's not like any part on her. It's like she did change some shifts and stuff, so I don't fully know the schedule.
Okay. Now, there have been times in this divorce action, like many others, that the two of you have not gotten along very well. Would you agree?
Yes, sir.
In the recent history, how would you describe your relationship with your soon-to-be ex-wife?
I would actually say that due to Mr. Wolf, since the last speech he gave us right here in Courtroom or via Zoom was it's actually gotten a lot better.
Okay. And are you able to recall what part of that speech seemed to make an impact on you?
Yes, it was his tone and the fact that we need to work together because it's not about my quarrels with her or hers with me. It's about raising our son.
And you have completed the co-parenting seminar, is that correct?
That is
And did you feel beneficial having gained benefit from taking that course?
so.
Okay. Now, you have also provided me with a pay stub, a current pay stub, is that correct?
That is.
May I approach your honor?
You may.
Guys, you can identify, is that a pay stub that belongs to you, dated 9/24 of 2021?
That is correct.
And it shows that you're employed by Sterling Incorporated, which I guess is the corporate name for K Jewelers.
Yes.
Okay. And that your gross pay through November the 24th of 2021 is some $37,207.91.
Yes.
Is that an accurate reflection of all the income that you earn right now?
Yes, sir.
Okay. You know, I'd like to move that into evidence.
Be marked as Exhibit 2.
And Mr. Cruz, how long has that been your income?
I just got promoted at the end of June.
In January of this year? Were you a manager up until that point?
Yes.
Now, at my request, you attempted to produce to me today your 2020 federal income tax return, correct? And for whatever reason, your software, did it allow you to print it?
Not properly. I couldn't seem to size it down to go on 2 separate pages.
Do you recall what your gross income was for 2020?
It's got to be around 26,000.
And does that number reflect your earning prior to receiving your promotion?
I'm sorry, could you say that?
You said your income was between 25 and 26,000, you thought, for 2020.
Correct.
Does that income amount reflect what you earned prior to receiving your promotion?
Yes.
At K?
Yes.
Okay. And does that number also reflect what a year in retail working during COVID-19 looked like for you?
For me, yes.
Okay. May I approach, Your Honor?
You may.
Mr. Cruz, I'm going to hand you a document here and ask what that document appears to be.
Yes, my tax return for 2020.
And it is the front page of your return,
That
correct?
is correct.
And is that an accurate reflection of your income that you earned in 2020?
And
No,
yes, sir,
I
yes.
object. He hadn't tried.
Your objection is to what?
I just realized he hadn't attempted to admit it yet.
Okay.
Mr. Cruz, what does that document reflect as your gross income that you reported to the IRS in 2020?
It looks to be 24,531.
And is that indeed the income that you earned in 2020?
Yes, sir.
Okay. Your Honor, I understand there's going to be an objection, so we can take that up, but I would like to move this document into evidence as an exhibit.
All right, exactly what is the document? Is it something that's an official government document, or is this something that he prepared?
It's an official tax document, but for whatever reason, he was unable to this morning, as I asked him to produce the entire tax return.
No, that's merely a sheet of paper. He could print anything on.
Let me see.
It's not an entire return. He could put any numbers he wanted on that. A way to know whether it's submitted or not. Whether it's accurate or not.
It's a PDF class.
I'm going to overrule the objection. It'll go to the weight to be assigned rather than admissibility. He's identifying it as an accurate copy of his face of his tax return. Question of whether it is or the weight to be given to it will be for me to consider. You'll be able to cross-examine him. If there was any evidence, I assume that we're at final hearing. There's been discovery about these issues. So if there's any evidence contradicting it, I'll certainly consider that.
Yes, Your Honor.
We'll mark it as Exhibit 3.
Now, Mr. Cruz, I would anticipate that your wife is going to ask this court to disrupt the status quo for you and your son and alter or change, probably to your detriment, the amount of time that you spend with your son. Do you see any reason that the schedule that you all have right now is not working?
Yes, sir.
Do you see any reason to change it really in any form or fashion, one way or the other at this point?
No, sir.
Now, you're not able to know what's going to happen in the future, are you?
No, sir.
With your schedule and the likes.
Okay.
So you would understand that if something were to change with your schedule, you would have to file something with the court
Of course.
to modify this schedule. But if given where you are right now, your work schedule, her work schedule, your proximity to each other, and your co-parenting relationship, you want the court to order what you've submitted as essentially what's in place right now, moving forward. Is that correct?
Yes, sir.
Now, you all separated you said in November of 2019. And at some point later, you were ordered to pay child support, correct?
Yes.
And did you start indeed paying that child support?
Yes, sir.
And how much was that amount?
It's 243.
$243 a month.
Yes.
And are you paying that amount of child support right now?
Yes, sir.
And you understand that in the permanent parenting plan moving forward, this court would have to perhaps look at an adjustment of that child support with current incomes, current schedules, current days with the child, healthcare, insurance, things like that, and arrive at possibly a new number. You understand that?
Yes, sir.
And you wouldn't have any issue paying that, whatever that amount is.
Well, I personally don't have a problem with it, yes, but as far as
Okay.
just depending on.
That's all the questions I have right now, Your Honor.
All right, we're at the noon hour, so let's go ahead and take our lunch hour before, and let you cross-examine him after lunch. All right. We'll be in recess for lunch until 1:15. All right. Mr. Jackson, you may ask.
Thank you, Your Honor.
And you may take your mask off again if you'd like, or you may keep it on, whatever you'd like. Same thing with you, Mr. Jackson. If you want to take your mask off, leave it on, however you choose.
Mr. Cruz, this latest case that's been made exhibit to testimony shows that your year-to-date income is $37,207.91. Is that correct?
Yes, sir.
And that's for 3 quarters of the year.
Yes, sir.
So if my math is correct, that comes to $12,402.63 per quarter.
Yes, sir.
So on an annual basis, that would be approximately $49,061.54. Is that right?
Yes, sir.
As opposed to what you were making when we did the original temporary parenting plan, which was approximately $2,080 a month.
Yes, sir. We're not able to calculate our commissions, and that 48 is my base pay.
You're now the manager at K2.
Yes, sir.
Don't the managers set the work schedule for people there?
Yes, sir.
So you could set your schedule to comply with any type of visitation as long as it was reasonable and it was within your time of days off. Is that correct?
I believe so, yes.
So you work on holidays, don't you?
Most of them. Most of them.
Most of them, right? Do you celebrate Christmas?
No, sir.
While you were married to Miss Cruz, did you allow Miss Cruz and your child to celebrate Christmas in the home?
I didn't disallow it, sir.
You wouldn't allow a Christmas tree in the house, would you?
I recommended against it.
And I believe that you refer to holidays like Christmas as pagan holidays, pagan worship,
That is correct. They do have pagan origins. Yes, sir.
and birthdays. I believe you refer to those as self-serving or self-gratifying days that should not be observed.
If you magnify it to just those words, then yes. Yes.
So when your child has a birthday, you don't celebrate, you don't give them gifts.
I get them gifts all year round, sir.
So when your son has a birthday, you don't get any birthday gifts, do you?
I probably would if I had that day off and I was able to spend it with them. I'd probably get them the same as what I do all the time.
Do you celebrate his birthday? You have like a birthday party, cake, you have kids over, people with you?
I mean, if it happened that way, then I would, but I'm not gonna just plan something accordingly.
Do you believe in immunization of children?
Certain ones, yes.
Pardon?
Certain ones, yes.
But which ones do you believe in?
I believe the polio ones is a good one. It is. It's about the ones that don't have massive outbreaks anymore. Like why we need to put these things in their bodies.
Like smallpox, whooping cough.
Or chicken pox, things like that.
So polio's okay, but you're not in favor of the other immunizations.
They haven't changed the polio one much since it was urged.
How do you feel about medical care?
I feel okay with that.
So you don't go for the immunization, but you don't have a problem going to a doctor for medical care?
That is correct. I have nothing wrong with the medical system.
When you were asking, when you were asked on the rec about your work schedule, I couldn't hear what you said about Friday and Saturday and Sunday.
Oh, Friday I'm off. Saturdays, currently the company has us from 11 a.m. to 7 p.m. And then on Sundays from noon until 6 p.m.
Do you know a lady named Kim?
I do.
And isn't she the young lady you were having an affair with before you and your wife separated?
No, before, so.
Didn't you go to marriage counseling about that?
We went to marriage counseling over a particular event that happened. At around that time, her husband had died, and she was one of our coworkers. Me and all of the coworkers in that building had all tried to pitch in or help in some way because she was left with 3 kids. That's what Ms. Cruz would be referring to. And we went to marriage counseling because I wanted her to know that there's literally nothing there.
Do you live with this Kim lady?
I do not.
What's her last name?
Constant.
You do drive her car from time to time to pick the child up, drop the child off for visitation, don't you?
No, sir. That was one time during the snowstorm. My vehicle could not get out of my particular driveway. So her and her daughter drove hers over to allow me to go pick up my son with that one and use it for work.
From the time that you and your wife separated up until this court put down a child support order, you paid no support, did you?
Correct.
17 months, no support.
I don't know if that's accurate, but there was no, I was seeing him fairly regularly after we got a court order to allow me to see him, that I was still supporting with the things that he needed. So.
You didn't pay any support. Didn't it concern you that your child might need things and didn't have the money for it?
Yes, that's why we talked at the exchanges.
Oh, but for 17 months, it wasn't all that important.
That's not the case, sir.
Then why didn't you pay it? Why didn't you pay some support?
She didn't ask or let me know if there was any additional things that he needed besides the things that I already provided for him.
What were those things?
Well, that would be at the very beginning. It would have been formula, food, diapers, clothes, toys.
Clothes, toys, and going out to eat.
Yeah.
That's your idea of support.
No, sir. Actually, I think it's the time that I spend with him.
Now, when you, in 2020 to about midsummer, you were employed at K Jewelers, were you not?
It was before summer that I was still technically employed with them, yes, but they had us go on to furlough.
You voluntarily quit, didn't you?
For a short time, yes. I thought I was going to pursue something else.
So how long during that period of time were you not working?
It probably wasn't more than a month.
You had some sort of a consulting job, didn't you?
Yes, for a firm that is creating software for cryptocurrency.
They paid you with a personal check, didn't they?
Actually, when I started, they Venmoed me, I believe, the one payment.
I believe that's all I have here.
Redirect, Mr. Sanders.
Yes. Mr. Cruz, when you all separated, did you have a last paycheck of yours that went into a joint account that you and Ms. Cruz accessed?
Yes, we did.
And did Ms. Cruz take the proceeds that represented your last paycheck at that time?
Yes, sir.
And do you recall how much cash she handed you when that account was liquidated by Ms. Cruz?
I'm pretty sure she handed me $300 out of that check.
And do you recall how much that check was?
I believe it was over 2,000. I can't remember the exact number.
And it's your testimony that you got 300 of that.
That's it.
In 2019, did you all file a joint tax return?
We did.
Mr. Cruz, I'm going to hand the officer here a document. He's going to hand it to you, and I'm going to ask, are you able to identify that as the joint tax return for you and Ms. Jenny Cruz that was filed with the IRS in 2019?
To be honest, I never actually saw it. This is the first time.
Does it appear to bear your name?
It does.
Does it appear to be a tax return?
It is
For what year?
2019.
And on the front page of that, I think it reflects an overpayment of taxes that was refunded to Ms. Cruz. Do you see that? Maybe page 2?
Maybe page. Yes.
Okay, and what was that amount?
It's like 2,634.
Dollars?
Yes, sir.
And was any of that refund shared with you?
No, it wasn't.
And to your knowledge, did Ms. Cruz receive that entire refund?
Yes.
And I'd like to move that into evidence as the next exhibit.
Mark is the next exhibit in order, which is exhibit 4, I think.
Now, since your separation, you all have also, most Americans received different payments from the federal government related to the COVID-19 virus. Is that correct?
Yes, sir.
And have you received or shared with Ms. Cruz any portion of those COVID-19 payments that would have belonged to her son?
Yes.
And she kept and retained all of those?
As far as I know.
And also, there are advance payments being made currently for the child tax credit. Are you receiving any of those payments on behalf of your son?
I'm not.
Since separation, have you claimed your son on taxes for any year?
Yes, sir.
These amounts that you testified to, if the court were to determine that you have a obligation for arrearages, would you like the court to in some way offset those amounts by these amounts of money that have been retained by your wife since your separation?
Absolutely.
That's all, Your Honor.
Mr. Jackson. Thank you, sir. You may step down.
That's my proof, Your Honor, subject to
Plaintiff is rested. Mr. Jackson, you wish to put on your client? Step around, please, ma'am, and raise your right hand.
Do you solemnly swear or affirm the testimony given in this cause to be the truth, the whole truth, and nothing but the truth?
Please state your name
Yes, sir. It's Jenny Ellen Cruz,
and where you live, Ms. Cruz.
104 Hound Road.
Now, since we were last in court, your monthly income of $43.33 remains the same.
Mostly, there has been a couple of times where we've been kind of furloughed due to COVID, but we received 8%.
But you're pretty well topped out at your job at this time.
Yes, I'm fully topped out.
Now, could you tell me when the two of you separated?
December 6th, 2019.
Not November.
No, sir.
What happened that occasioned separation?
We had I found he was spending time with a coworker, Constantine. We disagreed about it. We went to marriage counseling, where he was supposed to cut off all communication, not be alone with her anymore, not be going to meet her anymore. And the next evening, when I got in my car to go to work, or in his car in the road, he didn't disconnect the Bluetooth, and he was messaging her to meet up the next day on his day off while I was leaving for work.
What happened after that?
He told me that he wanted a divorce because I would not stop accusing him of misconduct with him, and I asked him to leave. I had heard from other people that she was coming to my home while I was at work. I didn't want that around my kids, on any of that.
Now, you have a child by prior marriage.
Prior relationship.
Prior
we
relationship.
weren't married. Yes, sir.
And how old is that child?
He's 11.
Now, since we had the last hearing, there's also been a change in what you pay for childcare. Is that correct?
Yes,
So you now pay how much?
I pay $150.
That wasn't figured in the last temporary plan, was it?
No,
And you provide insurance for the child?
yes,
Do you also provide insurance for Mr. Cruz?
yes, sir.
That's your health insurance. You're required to do that to your divorce, is that correct?
Yes, sir.
Has he ever provided insurance for you or your child?
No, sir.
Now, prior to June 2020, how many times did Mr. Cruz keep your son for a full 3-day visit?
Before June of 2020, he kept him for the full 3 days from March when we set the order until the very first week of 2020.
What happened in June?
We both went back to work from quarantine, and we stopped getting him for 3 days.
For how long?
He would get him 2 days instead of 3.
Is that his decision?
Yes, he said it was.
You pull that microphone just a little bit closer to you there.
Sorry.
That's all
Yes,
right.
sir. It was due to work. He would get him when he was off work.
So since June 2020, he's had the child not even 2.5 days,
That's correct.
certainly not 12 hours on Saturday.
That's correct.
And after the two of you separated, did you ever deny him visitation of the child till the court order?
2 times before the court order, I did. I felt it was in our son's best interest.
And what made you do that?
The first time was because, as he said, the birth certificates were missing, and he had threatened me previously during the marriage, and I heard from others that he was planning on taking our son back to Oklahoma.
And second,
I had been told by a mutual friend that he.
Objection, Your Honor. Calls for hearsay.
Can't repeat what someone else says. Mr. Jackson, it seems to be hearsay. Do you have an exception?
no, sir.
All right, sustain the objection.
Did you receive information that made you think he was sick?
Yes, sir.
Sick with what?
COVID.
It's a backdoor way to get hearsay admitted into evidence. I object.
Well, what's the purpose of introducing this information, Mr. Jackson?
Purpose is, he testified on direct that he didn't get to see the child often. She refused visitation. I'm trying to show when she did, why she did.
Overrule the objection. I'm going to allow the testimony not because it's being admitted to prove the truth of the matter asserted therein, which is the definition of hearsay, but rather to show why she took certain actions. So that's the basis for the allowance.
Other than those 2 times, did you ever deny him visitation when he asked?
No, I always try to work with him on this.
And currently, this this Saturday morning turnaround thing, how is that working?
Well, 2 weeks ago, the text message I received was, as tradition has it, I'm going to be late again. Because about 95% of the time, he's 30 minutes to an hour late. And it's been longer than that at times.
How long has that been going on?
Only since our last court hearing on April 7th. Before that, we didn't do morning exchanges. It was always Wednesday night to Friday night. After court, it all of a sudden changed from Wednesday night to Saturday morning. The morning exchanges are very-
So what would be your preference as visitation?
Well, my preference, due to the fact that he has a brother and they're very close to each other, would be for 1 week his visitation to match his brother's visitation, so that they're not spending 4 days away from each other a week, only 2. So Friday night to Sunday night 1 week, and then keep it the same on the opposite week, like we have now, Wednesday to Friday.
And that way, the two half brothers would be together for at least 1 week.
Yeah, if we did that, they wouldn't spend more than 2 days a week away from each other.
Do you think that would be in the best interest of both your children?
I do.
During your marriage to Mr. Cruz, were you allowed to have Christmas trees in the house?
No, sir.
Why not?
Because he said that we could not, that he would not be in a home that had a Christmas tree or celebrated any pagan holidays.
Pagan home.
That's right.
Did he make these expressions in front of your child?
Yes.
Did you celebrate any birthdays for your child?
No, sir.
At Christmas, did he buy the child any presents or allow you to buy the child presents?
No, sir.
I believe you told me some Bible scripture he quoted for that, about the Christmas tree.
Yes, before we were married, the only issue that I knew of was with a Christmas tree itself, he said, and he showed me, we talked on the phone when our relationship started, that there is a verse in the Bible that says, a man shall not go out into the forest and cut down a tree and bring it into their home and decorate it with silver and gold. And because of that, he didn't want a Christmas tree in the house. Everything else was okay until we got married and it changed.
Did you know his views about pagan holidays before your marriage?
Only the Christmas tree part.
What about other holidays? Like 4th of July, Thanksgiving, major holiday?
The 4th of July was okay because it was an American holiday, so we could go watch fireworks, but all of the other ones was a no.
Just a flat no.
Yes,
And what about your child's birthday? Just a flat no?
no birthdays,
What was his explanation for that?
because he was not going to allow his family or raise his children that way,
Which way?
a pagan way. It was a sin against God.
Are you a Christian, Ms. Cruz?
Yes, sir,
How often do you go to church?
as often as possible.
Where do you go to church?
Victory Chapel.
How long have you been going to church there?
Several years on and off.
When your children are with you on Sunday, do you take them?
I do.
Did your husband, I assume since the court order, he's been paying child support
Except for June.
this June?
Yes, sir. He paid every month but June.
He did not pay you in June.
No, he paid September this morning. He paid at the end of every month, he'll make a payment through Cash App. He paid April, May, July, August, and this morning he paid September.
Did he pay you any support from the time you separated to the court order?
None. And none of that stuff came to my home.
Now, there's a place on these parenting plans for major decisions.
Sir.
And one of them is medical decisions. Necessarily would include immunizations.
Yes, sir.
Do you have a problem sharing major decisions with them on medical?
I do.
And why is that?
Because he told me that he does not want our son to be vaccinated, and I think that our son has the right to be protected against deadly diseases. I think it's in his best interest, and so does his doctor.
Now, could you tell me what happens with, visitation from, let's say, 1st of November to the end of the year with him?
Oh, it changes to 1 day a week from Thanksgiving until the 1st week of January.
Just 1 day a week?
Yes, he works 6 days a week during the holidays, all of them.
So you'd have the child 7 days a week, you'd have the child 1 day.
Well, I have 6 days.
6 days.
Sometimes a half day, like Thanksgiving was a half day, Christmas was a half day.
But as to educational decisions, non-emergent, religious, do you want to share religious upbringing decisions with him?
I don't think that's really a choice. He's gonna be around his father, he's gonna know his father's beliefs, just as he'll know my beliefs.
You want your child to be reared as a Christian?
I do. I want him to know that God has love for everyone, which is completely opposite.
And that's all you want.
Mr. Sanders, you may cross-examine.
Ms. Cruz, did you bring a pay stub with you here today?
I did not, my pay has not changed at all from those pay stubs.
And all that we would have to take is your word for that? You don't have a pay stub with you?
No, I don't, wasn't.
What is your rate? What do you, are you on a salary or hourly?
An hour,
And what is your hourly rate of pay?
$25.75 an hour.
$25.75 per hour. And you work how many hours a week?
It's up in the air right now, but typically I work 40 hours a week.
Sometimes more.
Yes, sometimes less.
And how much, you said a number a while ago, 43 or something. What was that number? 4,300 or something?
I'm sorry. what are
You
referring
testified
to?
earlier about what you made a month.
I testified about my yearly income from my last W-2, it's 40,000.
In 2020.
Yes, I believe so.
And you also talked about a parenting schedule that you would like this court to adopt. Did you prepare a parenting plan and propose that to the court today?
Sir, I don't prepare any of the paperwork my attorney does.
So you don't have one as far as you know. There's not one that you're going to submit to the court.
I only have what I spoke to my attorney about, I'm not aware of.
Okay. Okay. Now, where do you live?
104 Pond Road in Houston.
And with whom do you live?
Myself, my 2 children, a live-in nanny that watches them from work. My toddler.
And this nanny, are you in a relationship with this person?
Of course not.
Have you ever been in a relationship with this person?
No.
Have you dated women in the past?
A very long time ago.
Okay. So what's your live-in nanny's name?
Her name is Ayla Brooke McCollum. She prefers to be referred to as Brooke.
And how long has Miss McCullum lived with you?
Since March of 2020, when I lost my last babysitter.
And it's your testimony that you paid her $150 a week.
Yes, sir.
Did she go up on her prices or?
Before I had Brooke, I only had to pay $100 a week, but my babysitter refused to watch my son after Mr. Cruz threatened to show up at her home.
And that was when he wasn't being permitted to see his son, correct?
Yes, sir. No, he was seeing him. That had nothing to do with it. He didn't want to have a babysitter at all.
He wanted to visit with his son. He wasn't being permitted to do that. Is that accurate?
Yes. He wanted to pick him up in the middle of the night.
And so Ms. McCullum lives with you,
Yes.
correct? Does she pay you rent?
No,
She does not pay you rent.
that's part of it. That's why I only have to pay her $150 a week. But I don't have any way to calculate anything else for that.
So she pays you $150 a week, and in exchange for that, she lives at your house. And you pay the mortgage or the rent, correct?
The rent, yes,
The electric bill, the water bill, any other utility bills,
that's right.
you pay all of those things.
100%.
So there must be some value in your mind to the fact that she's able to live with you,
Yes.
correct?
My son gets to go to sleep and wake up in his own bed every day. He does not get disrupted. I think it's the best atmosphere that I can provide for him.
Ms. McCullum, she doesn't pay rent elsewhere.
No.
Correct?
That's correct.
You earlier saw when I showed your attorney your 2019 tax return,
Mhm.
and it showed a refund. Did you receive that refund?
Yes, sir, I did.
All of it?
Yes, sir.
Okay. And Mr. Cruz also testified that there was a last paycheck that went into a joint account.
Yes, sir.
You withdrew and liquidated it and gave him $300.
I paid our bills and gave him over half of what was left.
He says you gave him $300. You disagree with that?
I do disagree. There was $60 that was put into the road for him.
Into
and
the- into the what?
into his road before he went to work.
Hmm.
And another 300 that I gave him before he left, which left less than $300 for me, 280.
So you gave him 360
Mhm,
and used the rest of it to pay y'all's bills,
mhm.
and you kept 300 of it.
I kept $280 for food
Okay.
and gas for me and my children.
Okay. And he also testified that you've received, to the best of his knowledge, the COVID-19 payments that have been made on behalf of your son. Have you received those and kept those?
Yes,
Also the child tax credits.
yes.
Even though you haven't submitted a parenting plan for me to look at, can you go over what you propose to be your schedule again?
I would like it to match my son's brother's schedule, so that one week it would be Friday night to Sunday night, and then the opposite week we would keep it as we do now. I would like it to be Wednesday night to Friday night. I would prefer not to do the Saturday morning because of how disruptive they are and how unreliable the time is on when I'm actually going to be picking him up.
So, as I understand it, you would like so right now, can we agree that that your husband is with the child when he's with him all day Thursday, all day Friday, and then up until he drops him off to you on Saturday morning?
Yes,
Can we agree on that?
yes,
And also on Sunday or Saturday, Wednesday evening when he gets the child from you,
yes,
the child is with him exclusively. Now, hypothetically, if the court were to order the schedule that you would propose, every other weekend, he would have Friday at 6 until Sunday at 6. You've heard Mr. Cruz testify that he goes into work on Saturday morning, correct?
yes, sir.
At which time the child would come to you, and he also works on Sunday, correct?
Yes.
At which point the child would come to you.
Mhm.
So is this about your other son? That you're trying to maximize time with your other son?
I think it's about both of my children maximizing their time with each other. And being that Mr. Cruz worked at K Jewelers when he lived with me, and I know that the other managers were able to write their schedule pretty much how they wanted, and they took weekends off when they needed to. That I don't understand why that would be different for him being a manager writing his own schedule every other week. I don't think it's unreasonable to do what's best for our son.
Well, you're not an executive at K Jewelers, are you?
No, sir.
And you don't know how managerial roles are operated at K Jewelers, do you?
No, just what he told me.
So essentially, in essence, what you're asking this court to do is take the time Mr. Cruz is getting right now and cut it in half. Correct?
No,
Tell me how this is not a half of his time that he's getting right now.
the literal only difference would be the nighttime to Saturday morning difference. I believe he would be fully capable of switching his schedule. I don't think that's unreasonable. I don't think it would take any time away from him. I think it might make the time better, as a lot of the things that you can do with children are on the weekends.
You carry health insurance for your son.
Yes, sir.
Do you have anything here today to reflect what that amount is?
That's already been turned in the paperwork.
But you don't have anything today that you can submit to the court for that? It would be on a pay stub, but you didn't bring it, correct?
All right, just the old pay stubs that are already in there.
Now, you mentioned going to church and different things. Where did you say you go to church?
Victory Chapel.
Is this the same church that you testified to last time?
Yes, sir, it is.
I think your uncle is the preacher there.
No, sir. My cousin preaches there sometimes.
Cousin.
Mhm.
And what's the address of the church?
I'm not sure the exact address of it. It's on Nolensville Road. in Nashville.
And what denomination is that church?
It's Christian.
Christianity is a religion. What denomination is the church?
I guess it would be non-denominational.
And you said that you go there often.
Yes, sir. As often as I can.
How often is that?
Almost every week. I would prefer to be able to go, like during the week and such, but I live too far away for that.
And what is your work schedule?
It is Sunday night to Thursday night.
So what time do you go in on Sunday night?
I go in between 8:30 and 9 o'clock after I put my son to sleep.
So you go in at 8:30 or 9 Sunday night. You leave your house.
Yes,
Correct? You're not caring for it.
that's correct. He's asleep.
And what time do you get back home?
I usually get back home by 8 o'clock in the morning.
And you do that daily up until Thursday evening, and you get back home about 8?
No, Thursday morning. when I
Thursday
get home.
morning?
Yes. Or Friday morning when I get home at 8.
Now, you recall that we had a court hearing back in April
Yes,
this
sir.
year. And at that time, Judge Wolf ordered that the non-custodial parent would have the right of first refusal for visitation with the child during the time that child care is required by the opposing party.
Yes, sir.
You recall that?
Yes, sir.
So every night during the week, you need child care, correct?
That's correct.
And that hasn't been offered to Mr. Cruz a single time.
I was advised on counsel that while my son is sleeping, that does not account as parenting time. He's fully asleep when I leave every night. I wake him up every morning.
But you haven't asked Mr. Cruz if he would like to have him sleep over any night
No, sir.
since that schedule started, correct?
That's correct.
Although the court order would say that you were to afford him that opportunity at least.
I did inform him of my schedule.
Did you ask him, say, hey, I've got to leave at night. Would you like him to come over to your house and spend the night? And I'll pick him up in the morning.
No, I did not ask to wake my son up from the sleep for him to go to his father's house and then get up earlier than he normally gets up to come home.
Well, you could have taken him before he went to bed, correct?
And that would take parenting time away from me.
Have you done the co-parenting seminar?
Yes, sir.
And did you learn about maybe when it's not about me and it's about the child and those things?
Yes, I learned that a stable, steady routine is what is best for a child.
We brought up some holidays. You talked about how before you all were even married, y'all had discussed the Christmas trees and you were aware of those beliefs.
No, only the Christmas tree. I was not aware of any of those other beliefs.
Okay. But you knew how you felt about Christmas trees.
Yes, trees only.
And in fact, you all have celebrated Thanksgiving at your house, correct? When you were married?
No.
And
we were not
Ronnie and
allowed to.
Penelope came over and celebrated Thanksgiving?
No, sir, that was never allowed, actually.
Okay.
We did go to his mother's house, because it was not celebrating Thanksgiving. It was just spending the day off with his mother.
And do you recognize the fact that even though a holiday might not be recognized during visitation time, that the visitation time is still important for that holiday?
Yes, I think parenting time with my son's father is always important.
So even if he doesn't get a cake on his birthday or a present on his birthday, the fact that he's still spending that time with his or her, with his parent is important.
Yes,
You have another child, correct?
yes, sir.
And do you have custody of that child?
Yes, sir.
He primarily resides with you.
Yes, sir.
And does he visit with his father?
Yes, he does.
And what schedule does he visit with his father?
Every other week, Friday night, at around 6, depending on when they get there, until Sunday night.
So he sees his dad every other weekend, Friday to Sunday at 6.
And occasionally they might go on vacation or something, and the schedule will adjust. We co-parent very well.
And how old is he?
He's 11.
So except for that weekend where he's gone to his dad's twice a month, every other weekend, when your son is with you, this son is there too. Both of your boys are there.
Unless Corey's with his father.
So you agree that he spends a significant amount of time under your roof together with his stepbrother, his half brother.
Yes.
And surely you're not suggesting to this court that this court should limit little Corey's time with his father for the sake of your other child.
I don't think it's limiting. I think adjusting for the sake of both of the children is in their best interest.
It's reducing his time. Can you bring yourself to at least agree to that? Or is it beyond what you're able to understand or agree with?
Okay,
Do you agree that you would be reducing his time?
reducing his newly adjusted time since April. Yes.
That's all.
Redirect.
None, Your Honor.
Thank you, ma'am. You may step down.
Thank you, Judge.
Jackson, you have any other proof?
I don't know. Okay.
All right, both of you have rested. Do you have any rebuttal proof, Mr. Sanders?
I don't have any. I'm not going to put on any rebuttal proof.
I will hear you in argument.
In this case, this court has not really today, I submit, heard any evidence of anything that recently has occurred between these parties that I feel like would justify or cause warrant to disrupt the status quo for this little boy. We're talking from April of this year until now. We've had a parenting schedule in place, and there's just not been anything to show this court that it's not working. Contrary to Ms. Cruz, I submit she would have this court to look at this case from perhaps the perspective of herself or that of her other child. I submit this court looks at the case from the perspective of this little boy and the schedule that he knows and what's working and what he's become accustomed to. And that schedule is that these parties live just a very few minutes away from one another, both in Dixon County, which is, I submit, a good thing. The court recognized the need for both parents to be involved in this child's life and to maximize that time. And in doing so, put down a court order that gave him Thursday and Friday, which were his days off, and it carried it on through Saturday at 6, but said, you got to let her have the child back if you're not off on Saturday, which is what he's done. He takes the child back to her when he has to work on Saturday. Now, she hasn't necessarily done the same thing because she works at night. And if the order were strictly followed, each night the child would be spending the night with his father while she goes into work, and then she would get the child the next morning. Now, there's not been any contempt filed or about that, but I'm just pointing out, what the strict order or court order, how it would read. So what we have here, Your Honor, we've submitted a parenting plan in accordance with the statute. We've submitted a pay stub in accordance with what the court will need to set child support. His income is as reflected on this pay stub. We have nothing currently from Ms. Cruz. We have nothing to show what daycare she's paying to this live-in nanny who's obviously deriving some benefit from living there and having all her utilities paid and being paid childcare. So our parenting plan we submit is pretty in line with what the parties have been doing now for some time. Again, with the holidays, whether or not my client chooses to necessarily celebrate a holiday when he has the child is, to me, less important than recognizing the fact that the child is not in school and should have some holiday time with his father. We think our parenting plan is certainly reasonable. Her proposal, though not reduced to writing, I submit would drastically reduce the time that the child spends with my client. Additionally, when it comes into the calculation of back child support, testimony's been that Ms. Cruz retained certain sums of money for herself without sharing that with Mr. Cruz prior to the first court order. And we have the fact that she testified by her own admission, though my client said more times, that she withheld the child from him on 2 separate occasions between December and March when the parties first came to court. So her behavior there, I think, warrants this court look at and determining what, if anything, should be done due to that behavior on her. My client's a good father. He loves his son. They love the time that they have together. He's a well-adjusted little boy, smart, no abnormalities as it goes, just a perfectly normal little boy who no doubt loves both of his parents and needs both of his parents and wants both of his parents. And so I submit to the court, my client submits to the court, that our proposed parenting plan maximizes the time that he has available with his child in accordance with his work schedule.
Thank you. Mr. Jackson?
And his work schedule is what he wants it to be. He set the schedule as man. So adjusting to his schedule, adjusting to the schedule he sets. When we talk about behavior, that's a very, very nice term. And for 17 months, this man didn't give this woman a penny for support, not 1 cent, nothing. And then he wants to whine about she kept a check, the stimulus check. We didn't ask him, but I assume he got one too. What she's asking is to be paid support for those 17 months. And by his own admission, he didn't pay a dime. Secondly, that his income, he said $4,133.46 per month by the stub he submitted. And she'd be given credit for child care and for insurance. And that the visitation schedule be adjusted. It doesn't cut his time at all. Your Honor, you've been doing this a long time. On both sides of it. You know, we both get a little long in the tooth.
Careful now, Mr. Jackson.
But I'm sure you appreciate me bringing that up. But, you know, this schedule was adjusted at his behest. Instead of bringing the child back at 6 o'clock on Saturday for months now, she's been taking the child back to him in the morning, or he's coming in the morning. So he voluntarily cut himself back on Saturday more than 12 hours. And we both know that the guidelines for child care, you have to have a child for 12 hours or more, call it a day. So he voluntarily cut himself out of a whole day for which he's paying no support, I might add. That's an extra day she's keeping the child and he's not, even though he should keep the child. All she wants to do is try to adjust the schedule 3 days. One starting on Wednesday evening, one starting on Friday evening in alternating weeks, so that both her sons can be together on the weekend more often. That's all. It's not cutting anybody out of anything. And whatever Your Honor orders, I'm sure will be equitable. My client needs a cutoff time on these changes. She's waiting 30 minutes or an hour for him to show up, and she's just sitting there twiddling her thumb. And he even refers to it as the tradition that's set. Besides being totally ill-mannered, it's unexcusable. She should have to sit there in the car and wait. That's it.
All right. I will take my afternoon recess, and when I return, I'll give you my ruling.
All rise. Court is in recess. All rise. Circuit Court of Dixon County is back in session. You may be seated.
All right, for the record, this is the court's ruling on Corey, Leland, Darrell, Cruz versus Jenny Ellen Cruz. The parties have stipulated pursuant to the statute grounds existing for divorce to be granted to them without a finding of fault. And the court approves that agreement and therefore grants them a divorce. Let me make one change, if you will. The court finds that there is no real property at issue in this divorce case, and therefore there's no need to divide the real or personal property. There are no joint debts as indicated. So it really boils down to the adoption of a permanent parenting plan between these parties. And permanent parenting plan is often, in my opinion, a misnomer for what really is going on, simply because of the fact that, as the lawyers know, whatever decision I make today for the two of you is permanent only until the next time that you appear in court in front of a judge, me or some other judge. One of the few things that the law provides that a final order that can be modified is a parenting plan or a court order regarding the custody and visitation of children. You have a car wreck, you go to a jury trial and they award you a certain amount of money. You can't come back in 2 or 3 years and say, gosh, things have changed, I want more money. That's a final order and it cuts off your ability to do that. The only order that I'm aware of under the law that allows you to come back in the court and seek to modify what is essentially a final order is an order regarding the custody or support or visitation with minor children. So in that regard, whatever I'm ordering today is essentially temporary in nature, even though it's termed a final order. The two of you have been operating under a temporary order that you agreed to. Is an agreed order that basically says that the father, this is entered on April the 9th of 2020, signed by Judge Suzanne Lockhart Nash, and it basically gave Mr. Cruz temporary parenting time with the party's minor child every Wednesday from 6 p.m. until Saturday at 6 p.m. That's 3 nights and 3 days. Parties would meet at the Dixon Police Department to exchange the child. If the event he required child care during his time, the mother would be offered the first right of refusal. And it goes on to talk about the CDC guidelines and so forth regarding social distancing. Then you appeared before me in April of this year, and on April the 7th, almost 1 year later to the day, we had a hearing. And at that point, there was a request to amend the parenting plan by the plaintiff. And under that circumstance, there was also a motion for contempt. The court didn't find that the contempt issue rose to the level of intentional and willful contempt. But it goes on, and in the order, it talks about the fact that the prior order that was entered by Judge Lockhart Nash would be reaffirmed. And each party would provide to the other a schedule of when they're using child care. It does go on to reaffirm that the non-custodial parent shall have the first right of refusal to provide care for the child during the time the child care is required upon giving 24 hours notice. As of today, the right of first refusal is eliminated. The reason I'm doing that is simply because of the very thing that we just talked about. Mr. Sanders pointed out on cross-examination of Mrs. Cruz that she works at night. And by theory, in the wording of that order, every night, Mr. Cruz would have a right to insist on him providing the child care for your child. That's not what I think you want. I don't think that's what intentionally was intended by this order that was put down, and that I don't think either side intended that whenever she works nights that he would be able to provide care every night during the week. He might like that, but that's not I think the intent. So to eliminate those kinds of arguments and those kinds of issues, part of being a parent is providing care for your children. Part of being a single parent, if that's what you two remain, is to provide care for your children. Getting them to and from their activities, getting them to and from school, helping them with their homework. Those are all things that each of you are going to have to deal with as you parent your children. As a result of that, in my opinion, you're going to have to make your own arrangements. Now, if you want to use the other one for childcare and offer that to them, that is the best thing you could do. You'll find a willing recipient. There are those parents that will say, well, I'm not going to take the kids just to give you a free weekend to go out and party. There are people who will have that attitude. Unfortunately, that's all too often too common. But I would think that the two of you both expressed that love for your child and that you both want to be with your child. And as a result of that, it would seem to me the logical thing would be to offer it to the other, but it's not going to be a part of the court order. How you two treat each other and how you cooperate together will determine whether or not that becomes a regular thing that you can offer each other that opportunity. So, but under that prior order, the consistency that this child has had has been from Wednesday night every week with the father until Saturday morning at 9:30 when he goes to the mom because Mr. Cruz worked. So when I have to decide a parenting plan, first of all, there really doesn't seem to be much of an issue about the primary residential parent status, which we refer to instead of custody, but we're still operating under a statute that requires me to make certain findings for the record, so I will make those findings. This is pursuant to Tennessee Code Annotated 36-6106, having to do with child custody. So I look at the strength in determining and considering all of the relevant factors were applicable, including the following, then I'm required to look at, first of all, the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. Up until this point in time, when they separated, it seemed to me they had a fairly consistent sharing of responsibilities. Since that time, there was a period when obviously Mr. Cruz was not able to see the child as often as he would like to, and for that reason, Mrs. Cruz provided the majority of them. But since the April, for the last year at least, year and a half now, they have been sharing responsibilities and almost on an equal basis. And for that reason, I find that factor favors both. These parents are caregivers past potential for future performance of parenting responsibilities, including the willingness and ability of each of the parents to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, consistent with the best interest of the child. Now, and Mr. Cruz reference to what I had said to you that when you were here in front of me in April, it is, in my opinion, very important that the two of you try to set aside your own self-interest and put the interest of your child first and foremost in what you do in the situation. I realize how difficult that can be, and I realize that sometimes there's a symmetry between your self-interest and the child's self-interest, the child's best interest. In other words, it's in the child's best interest to have a good relationship with both of you. And to your credit, you both agreed back in April of 2020 to a shared parenting arrangement that allows that. In truth, what the statute that I'm referring to says, and this is our state legislature that adopted it, in taking into account the child's best interest, I'm referring to subsection A of that statute, in taking into account the child's best interest, the court shall, doesn't say may, doesn't say might, it says shall, order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child, consistent with the factors set out in the subsection. The location of the residence of the parents, the child's need for stability, and all other relevant factors. Court shall consider all relevant factors, including, that's where I'm going down this list. So both of you have, in my opinion, demonstrated the potential for future performance of parenting responsibilities, including a willingness and ability of each of you to facilitate and encourage a good relationship. Hopefully you've learned to set aside some of the animosity you might have for one another and to put the child first. So I find that factor is equally applicable. Refusal to attend the court-ordered parent education does not apply. Both of you have done that. Disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. There was a old judge that I practiced in front of on a regular basis, and he used to say two things to parents, especially fathers who fail to provide support for their child. One of them was, if it was up to you, Mr. Cruz, during that 17 months you didn't provide support for your child in the form of child support, Alan Wallace would have told you that if you were on trial for being a father, there wouldn't be enough evidence to convict you. I don't agree with that. I think I understand where you're coming from, but that's the way a lot of people would look at it. The other is the fact that you really can't consider what you have done in the way of giving support and say, I gave her what she needed when she asked for it or anything like that. That doesn't count. Tennessee law requires both parents effectively support your children. The offsets that you're requesting, which I'll deal with in a moment, are for monetary payments that were made not by you, but by some outside source that you're requesting to offset your obligation because she was retaining it. And to her credit, Ms. Cruz was attempting to try to support the child or children or the child on her own without any financial assistance from you. So under those circumstances, it appears to me that it really is important that you understand that the financial obligation, a parent's obligation to support his child is independent of his right to visit the child. That's the other thing people confuse. You might not be able to visit your child for some reason, but you have a legal obligation to support. Conversely, your right to visit the child is not dependent upon your support, so you should not be denied your right of visitation simply because you're not able to pay child support or not paying it. There's a method by which the court can deal with both sides of that equation. So that factor obviously would favor Mrs. Cruz in regard to the fact that she has been the one who provided all of that. The degree of, and the medical care, education, other necessary care, you have your own opinion about the necessity of vaccinations. You have every right to feel that way. Mrs. Cruz has a different viewpoint. Some people who are my age would, and I'm not advocating one way or the other. This is not a speech on behalf of vaccinations or against. I'm just simply observing when I grew up, you got in line and you went and got your sugar cube with a polio vaccine on it, and you didn't think about it. You also got your smallpox vaccination. You also got your tuberculosis vaccination. You just did it because you were told to as a child. And by doing that, essentially most of those were eliminated. I understand the argument against forced vaccinations. I understand your concerns, and there are legitimate arguments to be made on both sides. But someone has to make that decision, and I'll deal with that in a moment. But I do find that factor favors Mrs. Cruz. The the degree to which each parent has been the primary caregiver, this court finds that Mrs. Cruz has been the primary caregiver. The love, affection, and emotional ties existing between the parent and child, both of you love your child. I don't have any question about that. If you didn't love your child, you wouldn't be fighting over how much time you get to each spend with the child. But I think that you've got to make sure that your love and affection for your child doesn't lead you to do things that are detrimental to your own child's best interest, and that is to be arguing and fussing over every minute that you have. The emotional needs and developmental level of the child is severe. It's a 4-year-old child. I'll be honest with you, no matter what I do today, you're going to have to revisit this when this child starts school, unless you're going to agree to change the schedule during the week, middle of the school week. And I have my own thoughts about that, but that's up to you. But I don't find that there's anything particularly that would require that. Moral, physical, emotional, and mental fitness of each parent as it relates to the ability to parent the child. Both of you have made allegations about the other, at least you question the other, but there's really no evidence that either of you is anything but a good parent and a person who has the best interest of his child at heart and wants to do with the child. Child's interaction in relationships with siblings, other relatives, and obviously Mrs. Cruz has another son with this young man's brother, and they need to be able to spend time together. The importance of continuity in the child's life, and that is important here. The continuity of the child's life for the last year has been the schedule that I've touched on, which is from Wednesday afternoon with the father until Saturday morning at 9:30, from 9:30 Saturday morning until Wednesday at 6 p.m. So that is a factor that favors the continuation of that sort of a schedule. Evidence of any physical or emotional abuse is not present. Character behavior of any other person who resides in, there's no evidence about that. The child is not old enough to express a preference. The parent's employment schedule, the court may make accommodations consistent with that. I don't find that there's any real issues regarding that as well. So where we are then is for this court to make the determination of what is the appropriate schedule. It's this court's opinion that by agreement of the parties, you chose to divide the child's time in a weekly manner with a division of time to occur beginning on Wednesday night. But by the same token, I'm not inclined to continue putting an order down that says that Mr. Cruz will have the child from Wednesday at 6 to Saturday at 6 when he has to work on Saturdays. So as a result of that, his schedule from this point forward until school starts will be Wednesday at 6 p.m. until Saturday morning at 9:30, which is what they've been doing. I understand Mrs. Cruz's desire to try to have the change, but I think right now we're dealing with the consistency of the child. Your other son will be with him during the rest of those times. And that right now is the best we can do. It's my hope that when your son here starts school, which is probably a year and a half, 2 years at most, then you will both get together and try to come up with a schedule that will allow Elijah Cruz to have consistency with both of you without having an exchange in the middle of the week. But I'm of the opinion, because his schedule requires him to work that his schedule will be terminated Saturday mornings at 9 o'clock instead of 9:30, just to give him an extra period of time to get to and from work. And that brings me to the wait period. One of the most frustrating things for parents is to have to meet for a scheduled exchange of a child and wait and wait and wait and wait and wait. And they're afraid to leave because they don't know whether or not they're going to be in contempt of court. So there will be a 30-minute wait period. In other words, beyond 30 minutes, you're free to leave if it's an exchange of the child or whatever you choose to do. But he's under a court order. Mr. Cruz will have to have the child there at the appointed time. And after 30 minutes, he'll be considered to be late, regardless of whatever the factors are. I've already touched on the first right of refusal, which I'm eliminating based upon my opinion that that's just a source of constant problems and arguments. And while I've considered the request to alternate to the other weekend to coordinate with Mrs. Cruz's other son, it is my opinion that it's more my obligation is to ensure that this child in this case has a consistent schedule with his father. And then hopefully when school starts, you'll be able to do something different about that. Child support will be calculated on the current incomes of the parties as testified to in court. Mrs. Cruz, who did not provide us with the most current work paycheck, will have 10 days to supply your most current check so that we can determine your year-to-date income. And that allows us to do that. We'll then average out whatever you're making up to this point in the year and give us an amount that we can use to calculate child support. She will be credited with the payment of the medical insurance on the child. Obviously, after today, you're able to terminate the insurance coverage on Mr. Cruz. Mr. Cruz, I understand you'll probably get your own. Obviously, you know that you're no longer entitled and don't qualify after today. The work-related child care will apply only to the days that Mrs. Cruz actually has the child and works. Meaning, if it's on his weekend, you don't get a full 5-day week if you only have the children when you're working 3 days. So that's your work-related child care will be pro rata to the days that you actually have to have child care for work. That's, I think, consistent with the meaning of the child support statute. But to obtain that, because of the questions that have arisen or been raised regarding the lady that's staying with you, you're going to have to submit a sworn affidavit from this individual stating the amount that she's being paid and that she is, in fact, providing child care for this child. All right. That's the best I can do to satisfy you and Mr. Sanders about the question about whether or not this lady is or is not really being paid to stay there. Retroactive support will be from the date of separation based upon incomes of the parties at the time. If the parties have not exchanged income information, I know there's a 2019 tax return that was submitted, but both parties will pay their child support or calculate child support based on the actual incomes from the date of separation, which I find to be the date that Mrs. Cruz stated, which is, I think, September of 2000. December of 2019. Then from that day forward, that's the point when you'll calculate it. I've considered whether or not Mr. Cruz would be entitled to any of these credits. The paycheck that he deposited, obviously, Mrs. Cruz's testimony was it went to pay joint marital debts and the rest of it was divided. So I don't see that there's any credit that it would be necessary. The only other thing would be the federal government payments for child care or whatever that in my opinion, he is not entitled to credit for that. And the fact that he didn't pay any support for that length of time, in my opinion, does not entitle him to credit for that as well. Now I want to touch on the holidays, which are the last portion of this.
Before you, I want to make sure I don't know that you addressed the income tax return that they received.
Hold on just a second. What?
The federal income tax return that they received in 2019 that she testified she retained.
In 2019?
Yes, they filed a joint return in 2019 and it's an exhibit. And I think it was $2,600. And she testified that she kept that entire refund. He'll get credit for one half of that tax return, tax refund, because in fact it was a joint tax return. Then she will
she will keep her half, and then he'll get credit off the arrearage of child support for that amount. The only other issue then was the claiming of the tax deduction. They will alternate claiming the child for tax purposes on year to year, but it's conditioned on Mr. Cruz being current on the payment of child support. So we'll talk about holidays, and then we'll talk about the joint decision making. The court is of the opinion that the holidays will be alternated. Whether he observes them as a pagan holiday or doesn't observe them as a pagan holiday doesn't concern me. Most of the time, I don't know. I understand what Labor Day is about. I understand what Memorial Day is about. I'm not sure the children do appreciate it as much. If Mr. Cruz doesn't want to observe them as a holiday, he nonetheless will have time with his son if he's off from work. So we're going to give him the alternating holidays like that. The only one I'm going to make a change on is the Christmas holidays, because there is a specific connotation to Christmas. Now, Christmas, I'm just going to tell you, when I was a child growing up, whether it was, I didn't think much about it. I was raised in the Church of Christ, and we didn't observe it as a religious holiday. We observed it as a common celebration. I thought about Santa Claus. I thought about Christmas trees. I thought about all of the magic of Christmas, about all those things. Whether that's right or wrong, that was the way it was that I was raised. And some of my best memories of all my life, dreams that I had as a kid about the toys I wanted to get for Christmas, were all having about Christmas. So you can deny your son that if you want to, that's fine. I don't care. But as far as this court is concerned, the Christmas Eve, which is one of the more important days, will be spent every year with his mother, who does observe and does want to celebrate that with the child. He'll get, so we're going to set the Christmas holidays at beginning on Christmas Eve, December the 24th every year. Whatever the schedule is, wherever the child is, he will be with the mother from 8 a.m. Well, let's make it 9 a.m. so it's not so late, so early in the morning. 9 a.m. on Christmas Eve. And that will continue until 2 p.m. Christmas Day. At 2 p.m. Christmas Day, he will go to his father, and he'll stay with his father until 6 p.m. on the day after Christmas, December the 26th. And then it will resume the normal schedule. All of the other major holidays will be according to what we normally do about alternating even years and odd years. And that gives you both equal amount of time. It just allows the child to be with the mother on the Christmas Eve, which is part of the actual Christmas holiday celebration. Which brings me to the last thing that I have to address, and that's the joint decision making. There are 4 major categories in a parenting plan that the court has to consider regarding that. And those are educational decisions, non-emergency health care, religious upbringing, and extracurricular activities. Those will be considered to be joint. Now, the reason that I'm going to make a modification of that is that they will be joint, and the parties will consult with one another. After consultation, if the parties cannot agree, then the primary residential parent, which I've designated as the mother, will have the final say as to make those decisions. Now, that gives you the ultimate right to make these decisions regarding health care for your child, to make these decisions regarding religious upbringing and extracurricular activities. But what you've heard me say is after consultation, Mr. Cruz has the right to express his beliefs and to say what he thinks should be done. But the two of you cannot have, when you can't agree on these things, you can't have equal say in it without then forcing you to come back into court every time there's any decision that can't be reached. So hopefully the two of you will consult, discuss, have a reasonable, articulate, and calm discussion of these things, and then hopefully you can arrive at a joint agreement. If you cannot, then it will be your obligation. Most of the time, I'll tell you that when I was practicing law, and since I've been on the bench, most of the non-custodial parents who are upset about the decision-making process are most upset because they suddenly get informed that a major decision in their child's life has been made, and they didn't know anything about it until after it was already a done deal. Well, that's why I'm requiring you to consult with him beforehand so that he's involved in the process. He may disagree with you, and you'll have the final say, but he's going to have his say about what should be done. And that's the same as if the two of you were still together. the two of you were still together, you might have discussions about what would be done, but somebody in that family unit would have to make a final decision, or else no decision could ever be made. Now, clearly, you two have not been able to get along and coordinate about everything, but in my opinion, that will require you to have some sort of thing. I talked to you. Is there anything I haven't addressed then that you can think of in this case?
Well, I just wanted to ask the court about fall break, spring break, and then our request to have a week, each of them in the summer for a vacation.
You request to have one?
I think our parenting plan requested that each parent would have the child for one uninterrupted week during the summer, so that if either one of them wanted to take a trip.
Well, that's what I tend to consider the standard holiday situation. Child's not yet in school, but yet we'll go ahead and deal with that so that when the child does start school, your plan says that all vacation will be divided equally between the parties as they may agree. Is that correct, or am I looking at the one that was submitted by the mother?
I'm not sure. Mine doesn't say as they may agree. It just says that they'll equally divide fall break. It's 2 weeks, I
Is
think.
it your plan was the one that was attached at the beginning? Is that what you're saying? Or did you submit a second one?
The one I submitted today,
That one, I'm
I
not.
think that first,
that was an exhibit today.
All right, okay, all right.
It divides fall break, it divides spring break equally, and it gives each parent 1 week during the summer.
Well, there are only two ways of doing it. Fall vacation sometimes sometimes have a fall vacation, sometimes we don't. Mr. Jackson, do you have any problems in dividing the school vacation, the fall vacation when the child starts school?
When they start school,
When they start school. All right. When the child starts school, then we'll divide equally the school fall vacation, and that will be determined by the Dixon County school schedule. And you will let's let father will have the first half of the fall vacation when school begins. Pardon me, and the mother will have the second half, and then for spring vacation, she will have the first half and he'll have the second half. Each party will have at least one. And how much vacation do you get a year?
So I earn 4 hours of PTO. I get 40 hours of vacation, and I get 2 weeks every 6 months and every holiday off.
They have any job openings over there at
They have
Nissan?
so many job openings. So anyone that needs a job, we just.
I've actually heard them
Okay.
advertising it.
Yes, please
So-
send them our way. I'm
Well, I guess I'm stuck where I am because I'm running for reelection, but it is a situation where you have a pretty good job. I hope you hold on to it. Let me say this. I'm of the opinion that both of these parties should have at least 1 week until the child starts school, and then they'll have 2 weeks. Yes, ma'am.
I think that's right.
Let me see what she's got to say.
Could we not limit it to summer in case, you want the vacation be at some other time of the year? Right now, it's not in school. If you want to take vacation, whatever, you had just told me earlier today.
So this is exactly what I'm talking about, trying to cooperate with each other about trying to work things out. That's where you and he are going to have to start talking about those kinds of things and work it out together. Clearly, if for example, he's got time off from school, the children have time off from school in fall, and he wants to take a vacation outside of the summer, then that's something the two of you can agree. Now, I'm going to suggest to you that the best way to do that is to put it in some form of writing. Email it, text message it, or whatever, but make sure that it's not just an oral agreement so that you can both rely upon it. And then there won't be a question when it comes time for me to have to deal with it. So, but yes, I think right now, 1 week during the summer until the child starts school, and then after the child's first full school year, you'll go to 2 weeks during the summer to be agreed upon. And if you can't agree, then I'll set 1 week in the month of June and 1 week in the month of July for each of you.
Those are non-consecutive.
Non-consecutive. And that way, you can both schedule it, and let's just eliminate the, because I have to be unfortunately pessimistic enough to think maybe you two can't agree, but I hope you will. Let's put the first week, the first full week of June will be the father's, because of the fact that we'll say he'll have the first full week of June as his week. The first full week of July will be your week. All right.
What was the father-in-law?
Father's will be the first full week, and then hers will be of June. Hers will be the first full week of July.
I think I have two last questions, Your Honor.
I didn't ask you if you had any more questions. Go ahead.
Well, I appreciate that, but I'm trying to not,
No, I want you to, let's eliminate all the questions.
you said that the parties would alternate claiming the child on taxes, assuming he's current. He's going to start out with an arrears. Is the court counting that arrears that he's starting out with as him being not current?
Go ahead, Mr. Jackson.
My
We have to-
client just told me that she had claimed child as exemption. Let's do it this year.
So with the child tax credit he was referring to, they go by your last year's tax return, which I claimed my son, so they're sending me money for him. If I don't claim him next year, then that will be counted against me and I'll have to pay all of that.
All right, she'll claim him for that year then,
And then
This
we'll,
year,
this year.
and then next year we'll claim.
All right.
Thank you, sir.
I think it's really, technically, as long as he owes the child support arrearage, he's not entitled to the tax deduction. So the sooner he can pay that off, then the better he'll be.
And then finally, with respect to the arrearages, the court is setting the arrearage period from December of 2019 when the parties separated until the court ordered child support began.
And he's current on that child support,
And
if
then,
I understand
and then
correctly.
moving,
one month behind, good budget.
my client disputes that. We can address that, and I can assure the court that if he can't satisfy me that he's paid June, we'll take care of that. He thinks he has, but if he hadn't, he hadn't.
Well, he should have proof of the payment. So you two good lawyers get together and figure out whether he's current on that. If he's not current, then it'll be added to the arrear. He needs to bring it current. But the arrearages, we need to talk about how he's going to pay that too, because of the fact I'm not just setting an arrearage, he's going to have a payment. I don't have any idea how much that's going to be, but I would assume it's a substantial amount. So under the circumstances, normally we would give him an additional payment above and beyond his current support. You have any problem with that, Mr. Jackson?
No, I don't.
Since there's no real property for me to assess and divide the proceeds to do that. Right now, I'm going to set his payment on the arrearage at $100 a month. I think that's insufficient, but until I see what his current child support is, it's hard for me to know what the appropriate amount is. That will be subject to revisiting it. Mrs. Cruz finds that that's insufficient. Now that depends on the amount of the arrears that's calculated and so forth. So all of that will be dependent on what you end up with as a total amount of arrears.
So essentially, the parties will need to exchange income information for the year 2020 so that we can know what that amount should have been, and moving into 2021.
Correct. And I would like to, I told her 10 days, let's give you both 15 days to exchange all of your information regarding incomes that needs to be established. Your current paycheck plus your incomes for the year 2020 so that we know, okay?
Yes, sir.
All right. Anybody else have a question?
I believe that is all, Your Honor. Thank you.
Any questions, Mr. Jackson?
Yes, sir, John. We leave the child support payment for wage assignment.
He may agree to that. I don't know. Is that you talk it over until he's late on a payment? I'm not inclined to do a wage assignment, although in my mind it is the simplest thing. He doesn't have to worry about it. But you talk to Mr. Cruz about that, Mr. Sanders, and see whether or not he wants to agree to that. He has an arrearage, and that normally would be a basis, except that this is the final hearing, so it's not been a temporary. This is an arrearage that doesn't result from non-compliance with a court order. It results from non-payment of child support prior to It's retroactive rather than an arrearage. So I'm not inclined to do a child support wage assignment at this point until we determine if he has failed to pay. If he misses one payment, then we'll order, and that can be in the court order. If he misses or is late on a payment, then it'll go to a child support allotment, wage assignment. Anything else, Mr. Jackson?
Just one thing, Ron. Have a good evening.
One thing, what?
Have a good evening.
Oh,
Thank you.
thank you. I appreciate that. All right. Mr. Sanders, are you drawing the order since you're the plaintiff?
I'll try my best, Your Honor.
All right. Thank you.
Thank you for your time, Ron.
All right. Have a good rest of the day.